Dear students, welcome to the next video lecture of interpretation of a statute, which is on external aids to interpretation. I hope that you have covered most of the cases which I have discussed, which I have supplied to you with reference to internal aids to interpretation, and the role and value of internal aids of interpretation is clear to you by now. When it comes to external aids of interpretation, under external aids of interpretation, generally what is included is dictionaries, other statutes, which is also known as perimeteria, other statutes which are on the same subject matter, which are on a similar subject matter. So statutes in perimeteria are considered to be external aids. Other external aids are legislative debates, parliamentary debates, speeches made on the floor of the House, particularly by the minister or by the legislator who had moved the bill. Then the reports, various reports prepared by the parliamentary committee, reports, Law Commission of India report, and specific committees which are made on the reformation of law, in consequence of which certain changes take place, amendments are made in statutes. They are considered as external aids to interpretation. Now, what is the role or value of external aids to interpretation? That needs to be understood first with the reference to the concepts which are used as an external aid to interpretation, and then also the particular cases in which they are applied. I begin by dictionary. As a general rule, when the court wants to apply literal rule of interpretation, we know it is the plain meaning, the ordinary meaning, the dictionary meaning, of course. That's when the role of dictionary comes into picture. However, dictionary meaning on its own is not going to help us much, because if you go to the dictionary, then the dictionary will give you 2 or 3 meanings of every word. Now, which one of the meanings is to be incorporated and adopted in the particular context of the statute which is under consideration, that depends upon the context, right? So preference of one meaning over the other, which is provided in the dictionary, will always depend in the context in which a particular word is used. And therefore, as a general rule, if you have a word defined by the statute itself, then recourse to dictionary is not allowed. Why? Because the legislature had expressed its intention by defining and giving a specific meaning to the word. You can't in that situation go to the dictionary and try to override the express intention of the legislature by reference to the dictionary meaning. But when the meaning of a particular provision, word or expression is not clear, it is not defined by the statute, it is not obvious, and it has got various shades of meaning, it leads to confusion. In those cases, of course, dictionaries can be referred to, and they are referred to very frequently by our courts. Whether they are eventually accepted, whether the dictionary meaning is accepted or not, that depends upon the facts, peculiar facts and circumstances of each case, and what the judge wants to do with his interpretative exercise. Another external aid of interpretation is other statutes which are on the same subject matter. They are called statutes in perimeteria. For example, let us take the example of, say, Indian Penal Code and Criminal Procedure Code. They deal with the criminal matters. One deals with the substantive matter, other deals with the procedural matter. Now, if the question of interpretation of word public servant under CRPC comes before the court, then the word public servant has been used by Indian Penal Code as well. Then court can try to define the meaning of word public servant with reference to the definition of word public servant under Indian Penal Code. So generally, if two statutes are in pari materia, they are dependent on each other, they complement each other, then their meanings could be, the court can try to reconcile or to give same interpretation to words which have been used in both the statutes. But then again, this is not any fixed rigid rule which has to be followed in every case, because the same word which has been used in other statute, even if the subject matter is same, could have been used in a different context by the legislature. That possibility is there. So, court will have to look at the particular facts and circumstances of the case to find out whether the context in which the same word has been used in two statutes which are in pari materia, whether the intention is to use them in the same sense also, and then the court can of course rely upon other statutes for arriving at the meaning in the present case. Another very interesting external aid sometimes is the debates which take place on the floor of the house, on the floor of the legislature, floor of the parliament. This is an of course an external aid, and all these aids are external because they are not part of the statute. When you look at the notified act, notified statute, you don't find it in it. So this is external to the statute. That's why we are referring to it, and we can't refer to them at the very first instance whenever a question of interpretation is presented to courts. So, with reference to debates, there is divergence of opinion, of course, of the court. In some cases, it has been held that debates on the floor of the house, speeches made on the floor of the house, they have no bearing. They are to be excluded by applying the principle, by applying the rule of exclusion, because they are extrinsic, they are external. One speaker who is speaking in the house when a bill is proposed, a law is being passed, he or she may not represent the intention of the legislature in its entirety. So, to rely upon the speech of one speaker, to rely upon the speech of even a person who has introduced the bill completely may not give us the intention of the legislature. So, these reports, these speeches, these debates on the floor of the house cannot be referred to in the first instance. However, when the object and purpose of an act is not very clear, when the intention of the legislature is to be ascertained, and there are speeches and speeches available, debates on the floor of the house are available, then in those cases the court can refer to these speeches and then try to find out the intention of the legislature. And if the intention of the legislature is available, and the court is able to derive the intention of the legislature from by reference to legislative debates, then of course, and it does not contradict with the specific provision, substantive provision of the statute, then the court can make use of it. There was a lot of reluctance on the part of the court to adopt legislative debates and speeches on the floor of the house. Constituent assembly debates in particular were very reluctantly referred to, but over a period of time, the balance of judicial opinion is that if, particularly with reference to constituent assembly debates, that if the meaning of words, expression, or phrases on a particular subject matter, in statutes or even in constitution is ambiguous, uncertain, not very clear, then recourse can be had to the legislative debates, constituent assembly debates. Constituent assembly debates, we know, are very frequently referred to by courts these days to find out the intention of the makers of the constitution. Reports of law commission, reports of parliamentary committees, and reports of dedicated committees which are constituted to reform the law. They can also be referred to in certain cases where the object or purpose does not appear to be very clear. And in those cases, the reference to these reports can be made only to find out the intention of the legislature, to find out the object or purpose of the legislature. Of course, these reports cannot override the specific provision of the statute, but they can throw light on the meaning and the context in which word, expression, or phrases have been used. Similar is the position of a statement of object and reasons. A statement of object and reasons, is not an integral part of the statute, but it is appended when it is moved when the bill is moved to the house. In that situation, statement of object and reason can be used to ascertain, to find out the intention of the legislature, the object and purpose of the legislature. In those some rare cases where they are of help, then the court can go to statement of object and reasons as well. So you see, if we look at the external aids of interpretation and internal aids of interpretation, and we follow the general rules of interpretation about their use, you see the tone and tenor and the balance of authorities on external aids to interpretation, internal aids to interpretation appears to be somewhat in a similar league, and which is that if the specific provision of the substantive part of the statute is clear, if the meaning is very obvious, then internal aids, be it internal aids or external aids, they cannot override the meaning of a specific provision, which is fair. But when it appears to the court that the meaning is not clear, it is ambiguous, or application of the plain meaning leads to absurdity, inconvenience, or unreasonableness, then in those cases a reference to both internal and external aids to interpretation can be made. And try to make sense of these aids to interpretation, various aids to interpretation, in the context of the three main rules of interpretation that we discussed: the literal, golden, and the mischief rule. Particularly the mischief rule, whereby in the Hayden's case it was laid down that the court can look at the legislative history, the background, the common law which was prevalent at that time, and the reason why a particular remedy was introduced by the parliament or the legislature. What was the mischief which was sought to be remedied? What was the reason behind it? And then only to give only that interpretation which advances the remedy or suppresses the mischief. I think once you bring mischief rule of interpretation, once the court want to apply mischief rule of interpretation, with the acceptance of mischief rule of interpretation, with the popularity of purposive construction, everything which can throw some light on the object and purpose of the legislation, which can explain the intention behind making a particular law, which can throw light on the meaning, they can be referred to by the court legitimately, in particular cases at its own discretion, of course, and that will always depend on the subjective findings of the court judges who are deciding the case. Even the writings of scholars in newspaper articles, sometimes papers written in journals, opinion expressed in editorials, they are also referred to by the court to explain, to build its reasoning. Basically, all these rules, the main rules, subsidiary rules, and the aids of interpretation, they help the court to build its reasoning and to make the judgment more, give the judgment color of legal judgment, in the sense that it is based on the principles of law, rules of interpretation, and so on and so forth. Although we know that the judges arrive at the meaning arrive at the judgment first, and then they look for different rules, regulations, different principles of interpretation to justify their their decision. So, and most of the time these aids, these rules are brought into picture by the lawyers themselves. So, in the adversarial system of judiciary adjudication, what you have is lawyers trying to put a particular meaning with the help of all the rules, regulations, sources, external aids and internal aids available to them, to interpret laws which favors the cause, which favors the interest of their client. So judges with them have all the material available, and then they go on to decide which one is to be accepted and given effect in particular cases in which they are deciding. I will leave today you with one very interesting quotation from Justice Ochinappa Reddy, undoubtedly one of the best judges of the Supreme Court, about the interpretation. After this video, I would also, with the link of this video, I'll also send you some cases in which these various external aids to interpretation are referred to, and sometimes applied and sometimes not applied. I want to come to the opinion of Justice Ochinappa Reddy in Reserve Bank of India versus Peerless General Finance and Investment Company Limited, a 1987 AIR judgment of the Supreme Court. In this case, Justice Ochinappa Reddy observed, and I quote, "Interpretation must depend on the text and the context. They are the basis of interpretation. One may well say, if the text is the texture, context is what gives the color. Neither can be ignored. Both are important. That interpretation is best which makes the textual interpretation match the contextual." Do you get the point? That interpretation is best which makes the textual interpretation match the contextual. A statute is best interpreted when we know why it was enacted. With this knowledge, the statute must be read first as a whole, and then section by section, clause by clause, phrase by phrase, and word by word. If a statute is looked at in the context of its enactment with the glasses of the statute maker provided by such context, its scheme, the sections, clauses, phrases, and words may take color and appear different than what the statute is looked at without the classes provided by the context. So one has to look at the context, put up the glass of the context in which words, expressions, phrases have been used, and they will give us an entirely different meaning than what we might find when we don't have these glasses of the context. One point which is left out is as external in this unit 2. I see one of the topic is contemporanea exposito. One of the principles of interpretation is subsidiary rules of interpretation is contemporanea exposito, whereby if there is an old statute, ancient statute, and there is a question of interpretation about words, expression used there, then the rule is that interpretation should be given which had contemporary meaning. So the meaning of specific words, expressions may have changed over a period of time. When the court of present day is trying to interpret a statute, say 100-year-old or 150-year-old statute, then the court should try to place the meaning, try to adopt that meaning which was prevalent at that time when the statute was enacted. But however, this principle is not referred to when it comes to the modern legislation, recent legislations. It is only with respect to old legislation that it has got some value. Although even while interpreting old statutes, the court can say that the context in which words and expression and phrases have been used has changed over a period of time, and now we have to give it a contemporary meaning. And because if we give the old meaning, 100-year-old meaning, which was prevalent at that time to specific words or expression, then the provision may become OTOs, it may become obsolete, because so much has changed over a period of time. So this principle contemporaneo exposito is of very limited use for modern day legislations. It is sometimes referred to in the context of interpretation of ancient old statutes. So with this, I leave you with the link of this video, as well as certain other cases in which these external aids have been used, referred by the court, sometimes given effect to, their meaning has been adopted, sometimes they have been referred but they have not been used to give effect to the meaning suggested by them. With these words, I leave you with the cases, and I suggest you that you go through all the cases in which reference has been made to external aids to construction, external aids to interpretation, and in case you have any doubt, any confusion, please come back, write to me and come back to me so that I can discuss it whenever possible. Thank you very much.